Post-sentence terrorism detentions are a legal mechanism that allows the Australian government to keep convicted terrorists in prison or under strict supervision even after they have completed their sentences. The purpose of this measure is to prevent them from carrying out further acts of violence or radicalization that could endanger the community. The Criminal Code Amendment, High-Risk Terrorist Offenders, Act 2016 introduced this option for federal terrorism offenders who are deemed to pose an unacceptable risk of committing a serious terrorism offense if released into the community. The Act allows the Attorney General to apply to the Supreme Court for a continuing detention order, CDO, or an extended supervision order, ESO, for such offenders. A CDO can keep an offender in prison for up to 3 years, after which it can be renewed by another application. An ESO can impose strict conditions on an offender's release, such as electronic monitoring, curfews, reporting obligations, and restrictions on communication, association, and movement. An ESO can last for up to 5 years, and can also be renewed. The decision to grant a CDO or an ESO is made by a judge based on various factors, such as the nature and circumstances of the offense, the offender's criminal history, their behavior and attitude in prison, their participation in rehabilitation programs, and their likelihood of reoffending. The judge must also consider the evidence of expert witnesses who use risk assessment tools to evaluate the offender's level of radicalization and violent extremism. However, these risk assessment tools have been criticized for being unreliable, unvalidated, and biased. A report by the Australian Institute of Criminology found that there was a lack of research into the efficacy of these tools, and that they were not predictive of the likelihood of violent extremism. The report also found that some tools considered factors such as autism, mental illness, and social isolation as signs of criminality, despite the lack of evidence for such associations. The use of post-sentence terrorism detentions has also raised human rights concerns, as it infringes on the principles of proportionality, finality, and double jeopardy in criminal justice. Some critics argue that it amounts to preventive detention without trial, which violates the right to liberty and security of person. Others contend that it undermines the presumption of innocence and the right to a fair trial, as it relies on speculative future scenarios rather than proven facts. Since 2016, only 4 offenders have been subject to post-sentence terrorism detentions in Australia. 2 of them have been placed under ESOs, while 2 others have been granted CDOs. The constitutionality of this regime has been challenged in court by one of the offenders, but it was upheld by the High Court in 2020. The court ruled that post-sentence terrorism detentions were a valid exercise of federal power and did not infringe on state rights or judicial independence. Post-sentence terrorism detentions are a controversial measure that allows the government to keep convicted terrorists in prison beyond their original sentence, if they are deemed to pose a high risk of committing further terrorist acts. The Australian government introduced this measure in 2016, following a proposal by then Prime Minister Malcolm Turnbull. The measure was justified as a way to protect the public from the most dangerous terrorists who may not have been rehabilitated or de-radicalized in prison. However, post-sentence terrorism detentions raise serious legal and human rights issues that violate international standards. First of all, they undermine the principle of legality, which requires that criminal offenses and penalties are clearly defined and proportionate to the harm caused. Post-sentence detentions are not based on any actual offense committed by the detainee, but on a speculative assessment of their future risk. This assessment may be influenced by subjective factors such as the detainee's beliefs, associations, or expressions. Moreover, post-sentence detentions impose an additional penalty on the detainee after they have already served their sentence, which amounts to double punishment and violates the right to be free from arbitrary detention. Secondly, post-sentence terrorism detentions infringe on the right to a fair trial and due process. The decision to detain a person beyond their sentence is made by a state or territory Supreme Court, based on an application by the Attorney General. The court must be satisfied that there is a high degree of probability that the detainee will commit a serious terrorism offense if released. However, the court may rely on secret evidence or information that is not disclosed to the detainee or their lawyer, which prevents them from challenging the allegations against them effectively. Furthermore, the court may impose conditions on the detainee's release that restrict their freedom of movement, expression, association, or privacy. These conditions may be disproportionate to the risk posed by the detainee and may interfere with their rehabilitation and reintegration into society. Thirdly, post-sentence terrorism detentions violate the right to be free from torture and cruel, inhuman or degrading treatment or punishment. The United Nations Human Rights Committee has stated that prolonged and indefinite detention may amount to such treatment, especially if it causes severe mental distress or anguish to the detainee. Post-sentence detentions may have a detrimental impact on the mental health and well-being of the detainees, who may suffer from anxiety, depression, hopelessness or suicidal thoughts. Moreover, post-sentence detentions may expose the detainees to harsh prison conditions, such as solitary confinement, physical abuse or lack of adequate health care. In conclusion, post-sentence terrorism detentions are a draconian measure that fails to meet international human rights standards. They undermine the rule of law and due process, and may subject detainees to arbitrary and indefinite detention and cruel treatment. They also fail to address the root causes of terrorism and radicalization, such as social exclusion, discrimination, or injustice. Instead of resorting to post-sentence detentions, the Australian government should adopt more effective and humane measures to prevent and counter terrorism, such as providing rehabilitation and de-radicalization programs for prisoners, enhancing community engagement and dialogue, and respecting human rights and the rule of law. In this section, we will provide some examples of cases where post-sentence terrorism detentions have been applied or challenged and the outcomes or implications of these decisions. One of the most prominent cases is that of Abdul Nasser Benbrika, who was convicted in 2008 of being a member and leader of a terrorist organization that was allegedly plotting attacks on high-profile targets in Australia. He was sentenced to 15 years in prison, but his sentence expired in November 2020. However, he remained in jail after the Home Affairs Minister Peter Dutton applied for a Continuing Detention Order, CDO, under the Criminal Code Act 1995, which allows for the extension of a terrorist sentence for up to 3 years at a time if they pose an unacceptable risk to the community. Benbrika challenged the validity of the law that enabled his prolonged detention, arguing that it was punishing him for what he might do, not what he had done. He also claimed that it violated his human rights and the separation of powers between the executive and the judiciary. His case reached the High Court of Australia, which upheld the law and the CDO in February 2021. The majority of the judges found that the law was a reasonable and necessary response to the potential threat posed by radicalized offenders who could not be adequately supervised or rehabilitated in the community. They also found that the law did not interfere with the independence of the courts, as they had the final say on whether to grant or revoke a CDO based on evidence and submissions. Benbrika's case is the first and so far only one where a CDO has been granted under the federal legislation. However, there are other cases where CDOs have been sought or considered by the authorities. For example, in June 2021, it was reported that another convicted terrorist, Ahmed Nazmand, who was jailed for attempting to travel to Syria to join Islamic State, could face a CDO when his sentence expires in 2023. Nazmand has been assessed as having a high risk of reoffending and has shown no signs of de-radicalization while in prison. Another case where a CDO was considered but not pursued was that of Khaled Sharif, who was convicted in 2009 of plotting a terrorist attack on an army base in Sydney. He was released on parole in 2013, but fled to Syria with his family to join Islamic State. He was reportedly killed in a drone strike in 2017, along with 2 of his sons. The Australian Federal Police had sought advice on whether they could apply for a CDO for Sharif before he left the country, but were advised that it was unlikely to succeed due to insufficient evidence of his ongoing involvement in terrorism. These cases illustrate some of the challenges and controversies surrounding post-sentence terrorism detentions in Australia. On one hand, they are seen as a necessary measure to protect the public from individuals who remain committed to violent extremism and cannot be safely managed in the community. On the other hand, They raise questions about the fairness and effectiveness of detaining people beyond their original sentences without any new convictions or charges. They also pose ethical and professional dilemmas for the experts who are tasked with assessing the risk posed by these offenders using tools that may not be reliable or valid. In conclusion, post-sentence terrorism detentions are a complex and contentious issue that requires careful balancing of security and human rights considerations. They also require ongoing research and evaluation to ensure that they are based on sound evidence and principles.